Greetings from Toledo. Going to talk with you now about protecting your trademark outside of the United States. In the U.S., we have the Patent and Trademark Office sitting in Virginia, where trademark owners can register their trademarks. I work for several companies who export their products to other countries and apply their trademarks to their products in those countries. The U.S. registrations owned by these clients provide no protection outside of the U.S. Virtually every country in the world today has a system for registering trademarks, and many of my clients have taken advantage of an international system of trademark registration. That system is based on a treaty known as the Madrid Treaty, because it was negotiated in Madrid. And that treaty provides that member countries have the right to set up a system for nationals in those countries to make applications for international trademark registration, and in those applications request protection for their marks in one or more of the member countries. In the United States, an application for international trademark registration can be made in the United States Patent and Trademark Office. In these cases, the U.S. Patent and Trademark Office serves as a conduit, and so a U.S. company that makes an application has that application go through the U.S. Patent and Trademark Office, which sends that application to Geneva, Switzerland, to the World Intellectual Property Organization, which administers the international trademark registration system. A U.S. company must have a U.S. application or a U.S. trademark registration before it can make an application for international trademark registration. Before the U.S. Patent and Trademark Office sends an international application to Geneva, it will certify that application as one that corresponds with the applicant's U.S. application or registration. When the application reaches Geneva, the notice is sent out to the countries designated in the international application, and the countries that are designated receive a notice from Geneva indicating that an international application includes a request for protection in that country. And when that notice is received, the trademark office for that country will perform an examination of the information in the application. The examination in Europe is quite thorough. The examination in New Zealand, not so thorough. Each country, or region in the case of Europe, has its own standards for granting a request for extension of protection. Filing the international application does not guarantee protection in the countries that are designated. Ultimately, protection in those countries will be granted or denied by the individual countries. There are a lot of advantages to the international trademark registration system. We've talked before about the idea that a trademark owner can maintain a trademark registration by timely filing renewal applications. For an international trademark registration, a single renewal is required regardless of the number of countries where protection has been extended. This saves a lot of money for a lot of owners with trademark rights that are registered outside of the U.S. The international trademark system is also utilized by companies in countries other than the United States, and those companies can file a single application for international trademark registration. If that application requests extension of protection to the United States, the request will go to the United States Patent and Trademark Office, and the application will be examined. It's one of the most thorough and rigorous examinations given by any country that is a member of the Madrid Treaty. The application will be examined for formalities, and the mark will be examined for similarity to other registered trademarks. It will be examined relative to the possible descriptive nature of the mark, and if the U.S. Patent and Trademark Office approves the application for registration of the mark, the Patent and Trademark Office will publish that mark, just as it would the mark in a domestic U.S. trademark application. And anyone who believes that he would be damaged by registration of that mark originating in another country will have a 30-day window to oppose that registration. When the U.S. Patent and Trademark Office issues an examination report and the applicant wants to respond, it must be represented by a U.S. trademark attorney. Yay! I have had the pleasure of representing many companies outside of the U.S., primarily from Europe, in connection with their request for extension of protection to the U.S. in an international trademark application. We've talked before about the idea that the United States has a use-based trademark system, and the United States imposes an extra burden on owners of international trademark registrations with protection in the U.S. to maintain those registrations. Because our system is use-based, those trademark owners must file a statement that they are using the mark in the United States. This has to be done between the 5th and 6th anniversaries of the registration, and subsequently must be done every 10 years when the international registration is renewed. Yay for trademark attorneys in the U.S. Companies with U.S. trademarks who are considering doing business outside of the United States must take a serious and early look at protecting their trademarks outside of the U.S. The international trademark registration system is an excellent economic way to protect those marks outside of the U.S. And as I mentioned, maintaining that international registration is less expensive than maintaining individual registrations in countries where your mark is protected. Today, there are 87 countries that have ratified the Madrid Protocol. Europe has a community-wide system of trademark registration. More than one of my clients has obtained an international registration with a single designation covering all of the common market countries in Europe. This is a great system for protecting your mark in Europe with a single designation and a single renewal requirement to keep that registration in force. There's more information available on the international trademark registration on the United States Patent and Trademark Office. If you want to learn more, there's a link to those videos on the trademarkwahoo.com website. In the meantime, remember, you'll do better in Toledo.